Charging a firearm from June 12th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment...
All right, buckle up. This is how a first-degree felony arraignment unfolds. Notice how composed the judge remains, even as her computer lags. But don't be misled by her calm demeanor. What's about to be read carries life-changing consequences.
...is a minimum 5 years in prison, up to 99 years or life. Do you understand? Answer out loud, please. And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 15 years in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for...
Let that sink in. 5 years to life in Texas. Aggravated assault with a deadly weapon doesn't even require hitting someone. Simply pulling that trigger can lock you away for life. The stakes couldn't be higher.
I want to make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I also want to make sure you understand, Mr. Jones, that after today, unless there's some new evidence that the assistant district attorney or your attorney gets or finds out, that this offer will not be accepted after today. Do you understand? Okay, and so Mr. Jones, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial probably a little quicker. Is that okay with you? All right, Mr. Parker.
Now this gets interesting. Jones is changing attorneys right before trial prep. That can be either a calculated move or a last-ditch effort. Many defendants think their court-appointed lawyers aren't fighting hard enough. But switching counsel this late can seriously set back their defense.
Your release, Mr. Jones will appoint someone today. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. All right, sir, you're Stefan Budwin?
Yes, ma'am.
And let me get this pulled up. Is it?
And so if I can...
Hold on just a second. Let me just get what I need to, and then I'll let y'all. Oh, this is, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to Your Honor
Yes.
about on Friday. She bonded them out.
She actually, I wasn't sure about this. When I first, he called me yesterday and about a bond here. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case. And we were waiting on a PSI, and we were going to see what happened with parole. I think he's been released from parole. The parole hold's been lifted. No response. And then I get a call from her, and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was forwarded to me. And I told him that he needed to go and contact the probation department to do a PSI. I mean, I just told him yesterday. I don't know if he's contacted him yet.
Yes, they scheduled me to come in today. So I'm coming off the court.
Ms. Malfino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend, and I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time Your Honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday.
Here's where the emotions surge. Picture being so scared you break down crying in front of the prosecutor. Then, just days later, you ask to postpone for that same man. What makes someone do that? Fear, love, guilt. Let's see how the judge navigates this twist.
To you, Judge, and they were going to lift the hold, so that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously. And so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Budwin, I'm not going to increase the bond based on what we've learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she went and bonded you out. She's written me a letter. At this point, I don't care about it.
The judge isn't holding back when she says, "I don't care about any of that." Period. That's a hard line drawn. Judges often use sharp emotional language like this to make the weight of their words hit. One text, one call, and it's over. Back to jail.
Any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person, that's through your phone, that's through sending messages. Again, she cannot say, "It's okay, I won't tell." If something happens and she changes her mind again, which is likely, it sounds like, and contacts Ms. Malfino and says, "Okay, I thought it was okay, but now it's not, he's coming around," you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. You have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay.
Uh-huh.
Okay.
All right, okay, you're free to go.
Thank you, Judge. I just felt it important to document.
I totally agree. Thank you, Ms. Malfino. Good morning, sir. Are you Nevada Bates? I'm sorry?
Yeah.
And Mr. Bates, in cause number 25, DCCR 0834, you're charged with a first-degree felony offense of aggravated robbery from May 16th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison. You have every right to reject that. I want to make sure you understand if you pled to a cap, it means you'd be leaving your punishment up to me. If I follow that agreement, I can't give you more than 25. I could give you 25. I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have an absolute right to have a jury come decide all of this. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. I also want to make sure, Mr. Nichols, is there any reason to believe that that offer would change?
No, Your Honor.
Mr. Bates, unless there is some new information that the lawyers don't know at this time, I will not accept this plea agreement after today. Do you understand?
Yes, ma'am.
All right, Mr. Bates, also, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. Mr. Bates, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Oh, it is. I just read that completely wrong. I take back the gold star.
Well, no, there's
Or the
some-
lack of one.
There's some rejections coming.
There's. Good morning, sir. Are you Ryan? Is it Briones?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment in each
He
case?
will, Your Honor.
Mr. Briones, in cause number 25, DCCR 1106, you're charged with the first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
I'm guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 1108, you are also charged with the first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
and because you did what they've charged you with. In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation in each case. There would be a $500 fine. And then we would get a pre-sentence report done, and if there were any other recommendations or conditions such as ISF, that would be up to the court, and I could impose those at sentencing. Is that your understanding?
Deferred probation, a fascinating middle ground. It means if Biones finishes probation without a single violation, the felony can vanish from his record. But one mistake, and the full 10 years come crashing down. So what would you gamble? Freedom now or a clean slate later?
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted. Is there any evidence that Mr. Biones is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. I'm not going to adjust the bond just based on the nature of his age and the possibility of ISF. All right, you can go back with the bailiff.
Thank you, Your Honor.
Good morning, sir. Are you Derek Green?
Yes, ma'am.
And Mr. Green, in cause number 25, DCCR 1119, you're charged with a third-degree felony offense of obstruction or retaliation from June 19th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, June 7th of 1999, and then after that was final, you were convicted of possession of a controlled substance, a third-degree felony, January 5th of 2000, and then after those were final, you were convicted of possession of a controlled substance, a third-degree felony, January 28th of 2008. And what that means is if you're found guilty in this case, and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go forward on count 1 only for an 8-year term in prison and waive those prior counts that would make you habitual. You have every right to reject this offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject this offer and have your case set for trial?
Yes, ma'am.
I want to make sure you understand, Mr. Green, that after today, I will not accept this agreement. Once your case goes on the trial docket, it will either be tried to a jury or you can plead either open to the court or something different than that 8-year term. Do you understand?
Fine.
All right, so we'll get your case set for trial. Mr. Green, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. And Mr. Green, we will appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial.
Thank you.
You can go back with the bailiff. Good morning, sir. Are you Jacobe Lawrence?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Lawrence, in cause number 25, DCCR 1134, the state is elected to proceed on count 1 only. It alleges that you committed the third-degree felony offense of harassment of a public servant from June 12th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waived